Saanich North and the Islands on Clause 5.
Thank you, Mr. Speaker. And I just have a series of questions here with respect to Indigenous hunting rights. And in the late 1990s, Ivan Morris and Carl Olson were, quote, arrested and charged with several offences under the British Columbia Wildlife Act, including hunting wildlife with a firearm during prohibited hours, hunting by the use or aid of a light or illuminating device, and 3, hunting without reasonable consideration for the lives and safety property. That's Section 29. That's what they were charged under. As a matter of fact, the Morris case was one where they were hunting from a motor vehicle. Crown argued that this was inherently unsafe, but nothing they did was unsafe, and this was actually fought by the province all the way to the Supreme Court, where they were found that they were not hunting unsafely. The very issue here in Section 5. So I just want to ask this question: has the minister consulted with the appropriate Douglas Treaty and Treaty 8 First Nations on the impact of Section 5 on the treaty-protected rights as successfully defended in the Supreme Court of Canada?
Government House Leader.
Thank you, Honourable Chair. And in answer to your question, no, we are very much aware of those treaty rights and obligations. There will be continuing in the development of these regulations, further consultation with First Nations around this, and if there need to be and there is the ability to do exemptions under this, and we will ensure that if an exemption is required to ensure that those rights are protected, that one will be put in place.
Saanich North and the Islands.
Thank you, Mr. Speaker. And as my line of questioning unfolds, I think what I would like to be very clear on is that there's a strong differentiation between what is written in the legislation and then what is regulated. And I think that what's written in the legislation is actually very dangerous when it comes to those treaty rights. An excerpt from the R versus Morris Supreme Court of Canada decision. The Sartlip's right to hunt at night with the aid of illuminating devices is protected by the North Saanich Treaty. The historical context indicates that the parties intended the treaty to include the full panoply of hunting practices in which the Sartlip people have engaged before they agreed to relinquish control over their lands. One of those practices was night hunting, and as the trial judge acknowledged, night hunting by the Sartlip includes and always has included night hunting with the aid of illuminating devices, including from a vehicle, and that last part was what I have added. Even on a literal construction, the language of the treaty supports the view that the right to hunt as formerly means the right to hunt according to the methods used by the Sartlip at the time of and before the treaty. The right of the Sartlip to hunt at night with illuminating devices has of necessity evolved from its pre-treaty tools to its concurrent implements, the use of guns, spotlights, and motor vehicles, reflects the current state of the evolution of the Sartlip's historic hunting practices. Did the minister consult with Indigenous nations, including the Sartlip First Nation, the Saanich Nation, Nations, the 4 nations, the Douglas Treaty Nations, or the Treaty 8 nations?
Attorney General.
Thank you.
Sorry, Government House Leader.
Thank you, Honourable Chair. So in answer to your question to the specific groups you named, no, the consultation was done with the general First Nations leadership groups within the province. What I can also tell you is that this particular section is not a new section. It is replacing Section 9 of the old Firearms Act, so it is not new. It is just replacing what is already in existence. And as I said, we fully understand the treaty obligations that the province is required to honour. And if it is required for there to be an exemption, we most certainly will be doing that. This piece of legislation is intended to put in place a regulatory framework, and we've made that commitment that we will do just that.
Saanich North and the Islands.
Yeah, thank you, Mr. Speaker. In light of the declaration, and I I thank the Minister for acknowledging that the government understands its obligations under the treaty. However, the actions of the government has, over the last decade or so, and arguably the last couple of decades, 3 decades maybe, since Morris and Olson were first picked up in the 1990s, arrested on wildlife charges, the actions of this government has not demonstrated that they're prepared to do anything about the information that they have. Literally have sat on a 2006 Supreme Court case for almost 15 years. So in light of the Declaration on the Rights of Indigenous Peoples Act and the minister's admission that he understands the clear impact of this potential on in Indigenous nations, in addition to the fact that there was a commitment under the DRIPA that all new acts and even acts that were currently existing. So the fact that to the minister's initial response that this is replacing law that already was in existence, either way there was a commitment from this government to engage in Indigenous nations that are impacted by these laws. And if the government does know that the Sartlip in particular, but the Saitnich in total, and then as well the Douglas Treaty as a group of treaty nations, including the Treaty 8, who also have got similar language in their treaty, what did the minister use to determine that consultation at the legislative development stage was not needed?
Government House Leader.
Thank you, Honourable Chair. So in answer to your question, at the consultation stage, the groups and organizations who were contacted in terms of being consulted with were the BC Assembly of First Nations, the First Nations Summit, the Union of BC Indian Chiefs and Métis Nation, Modern Treaty First Nations, and the Nisga'a Nation. Comments were received from Indigenous treaty nations. The Nisga'a Nations were fully considered during the development of this bill. And the other point that I would make, as I said, consultation continues to be ongoing in terms of the development of the regulations, and this bill will not be implemented until those consultations are completed.
Member.
Thank you. And I think I should start, well, I should have started, but I will kind of now start by saying that I agree with the premise of this bill and the name of this bill, the Firearms Violence Prevention Act. I think it's important to acknowledge that the arguments that I'm making here today, or the questions that I'm asking the government today, are in the framework that I support the government's intentions to diminish the amount of firearm violence in our province. Now, part of the challenge is under the charges that Saitnich people in particular, but Douglas Treaty Indigenous people in general have been charged with. They've been at their heart safety-related matters. The Conservation Office will have arrested hunters, including Morris and Olson and Sampson now in 2016, based on safety. And they've actually unsuccessfully argued to the Supreme Court that there was an inherent unsafe aspect of the Sartlip hunt, or the Saanich hunt. So I'm going to quote the decision of the Supreme Court here. However, it is acknowledged that it could not have been within the common intention of the parties that the Sartlip would be granted a right to hunt dangerously, since no treaty confers its beneficiaries a right to put human lives in danger. This is confirmed by the language of the treaty itself, which respects hunting to which restricts hunting to, quote, unoccupied lands away from any town or settlement. Since British Columbia is a very large province, it cannot plausibly be said that a night hunt with illumination is unsafe everywhere and in all circumstances, even within the treaty area at issue in this case. Accordingly, while Section 29 of the Wildlife Act, which prohibits hunting or trapping, quote, without reasonable consideration for the lives, safety, or property of other persons, end quote, is a limit that does not impair the treaty rights of Aboriginal hunters and trappers, which apply without exception to the whole province, are overbroad and infringe on the treaty right to hunt. Something less than an absolute prohibition on night hunting can address the concern for safety. So I want to point out that in the, and I think that the language of this decision is that it was found the safety, that the Sartlip had a right to create laws over their hunting, and that there has never been an inherent unsafe lack of safety around the traditional hunting practices of the Saanich. So there is a troubling matter here that needs to be exposed, because the reality of it is that for a very long time, this provincial government has been trying to derogate those treaty hunting rights. And it could very easily be seen. In fact, I'm very concerned about the impact of the specific language of this clause in the legislation. And the minister continues to point out that, that this will be done through regulation, but what's in the legislation is really important, because the regulations can change. We've seen regulation change. Any government, any time that has its mind to it can change the regulation. We're in here debating this legislation. It is a slower process and requires this back and forth between the minister and members of the opposition to ask questions. This is an appropriate place for the consultation to have been done in advance of, not after this legislation is passed. So there has been 40 years of jurisprudence clearly stating the province does not have jurisdiction in this area around the federally protected rights to hunt. And yet we see in Section 5 that they are limiting, that the provincial government is attempting to overstep when it comes to Indigenous hunting rights, to overstep into an area that in fact they've been arguing in that 40 years of jurisprudence that they want the authority to overstep. So they're actually making that overstep in this law. What's really, really challenging, and I've got a long quote here from the decision that talks about the fact that in Section 88 of the Indian Act, it cannot be used to incorporate into federal law provincial laws that conflict with the terms of any treaty. The provinces may regulate treaty rights under certain circumstances. So what we have here is we have a situation where Section 5 is overstepping into an area, and as a lawyer who's argued this has pointed out to me, this really feels like an attempt to slip through the back door where going through the front door has failed. So did the minister or ministry staff review case law and acknowledge the limitations of provincial law in the context of federal jurisdiction when it comes to the treaty-protected rights of the Sartlip and others in the development of this bill?
Government House Leader.
Thank you, Honourable Chair, and I appreciate the questions from my colleague across the way, and I just want to assure him, first off, we're not trying, the province is not seeking to do something through the back door. The province is fully cognizant of its obligations, both in terms of how legislation is developed and ensuring complying with UNDRIP and treaty obligations. I can tell you that the issues that he's raised were considered in the development of this legislation. They were, that's why that consultation and the groups that I listed did in fact take place. And the question, and the concerns that the member has were not concerns that were raised back to us. But what I am telling the member is this, we have done consultation. I have made the commitment that those consultations are going to continue because we want to make sure that what we put in place is done correctly, is done properly, and and recognizes that there are, that rights around hunting exist. They have been established in the courts, and we are not going to we're not going to impinge on that or try to impinge on that by doing something through the back door. And as I said, until this is complete, that will not be implemented.
Saanich North and the Islands on Clause 5.
Thank you, Mr. Speaker. And I think it's important to, paint the picture of the potential impact of this. Carl Olson's my father, so I know this case really well. He reminds me of it often, and so he should. This charge that he successfully fought took 10 years of his life. And it's been 15 years almost since the decision was passed down, and yet nothing of consequence has happened. So if Morris and Olson Jr., if I and my cousin are out hunting and we get picked up and this law is passed, there's a decision point that could be made where we don't then get charged under the Wildlife Act. Necessarily, we get charged under this act. So what is solely a hunting case, which is argued to the Supreme Court of Canada about hunting, now becomes what looks like more like a criminal code charge under the Firearms Violence Prevention Act, Section 5, if it passes. Clause 5, as we're debating it now. So there is now this new, more robust law that then, and I should remind, the point has always been to undermine and erode those hunting rights. The province said as much, often as much, in the Morris Olson case. When the judge asked the Crown what their intention was with the fishing rights, my dad remembers this clearly, and he articulates to me clearly that the province said they wanted to get rid of those too. So, maybe they do. Maybe the conservation officer does have to charge us under a hunting violation. However, the question is, why is Sartlip members and Saanich members continue, if the minister's word is that the Crown fully understands its obligations under the treaty, why is Sampson still sitting in front of the courts today? Yet another Saanich member being picked up on yet another hunting case, questions about their character and their integrity, yet again being put before the people, so that then the Crown can yet again try to fight and undermine and erode the hunting rights of the Saanich people. Now, I can take the minister at his word. We've spent 3.5 years working alongside each other on this. It doesn't extend much past me, because there has been very little demonstration by the province a willingness to act. In fact, I have in front of me here a letter that was recently sent, as recently as February the 24th, 2001, to Minister Rankin, Minister Conroy, and Minister Eby, from the lawyer from the chief, Don Tom of Sartlip, highlighting a long case history starting in 1859, talking about the 1852, 7 years before the first Wildlife Act, Governor Douglas, the representative of this crown that we wear on our buttons, talking about a 1914 case from Edward Jim, talking about a 1916 case from Gus Morris, a 1965 case from White and Bob, that landmark case that changed the entire world here in Canada, talking about Section 88 of the Indian Act, talking about 1989 of the Saanich Bay Marina case that the provincial government lost in the Supreme Court, or the British Columbia Court of Appeal, talking about Dr. Barbara Lane, in the Bartleman decision, where the court established that the Saanich peoples hunting areas are far greater than just Satanich, than just Saanich. Talking about Section 35, then finally getting to the Morris Olson case, talking about the acquittal of the court, and then the key aspect, and then talking about the Sampson case. So there is a long history of cases with the Sartlip. And so I think the minister has to forgive the Saanich, the Sartlip, for when the minister says we're going to do this we're going to continue this consultation after the legislation is passed, after all the members of this place have demonstrated their support for this bill. The Saanich, the Sartlip, are just going to have to trust this government to reflect the rights that the provincial government isn't trying to overstep its right here, where it has been clearly defined that the Sartlip have a right to hunt from a vehicle. Have a right, and in fact, our traditional hunt was from the bow of a boat using pitch lanterns. And that was, so in this letter, the question is asked, why is the province continuing to pursue? If the province does know, as the minister said, why is the province continuing to pursue the prosecution of Jonathan Sampson? Is the province willing to end the prosecution and explore the other options contemplated by the province's legislative commitment? The Declaration on the Rights of Indigenous Peoples Act in reaching a co-jurisdiction agreement, building mechanisms for sharing information, designing protocols to avoid and resolve conflicts as they arise, and clarifying jurisdictional space the province will vacate over treaty rights. These court cases have all along, Mr. Speaker, identified the fact that there is co-jurisdiction in this area. Yet the province in this bill is operating and acting like it has the only jurisdiction. The letter from Minister Eby on behalf of the government in response was, it's before the courts. Of course it's before the courts, because this government and this province continues to arrest treaty-protected Indigenous people for undertaking their treaty right. And so you have to, I think the minister has to recognize how flat the response is, how flat it falls with people who have been fighting for generations to protect their treaty rights, to say, oh, the consultation will continue. Yet this government, the minister, the ministry did not actually directly consult, and I can confirm, I did confirm this morning, did not actually directly consult the Indigenous nation whose members continually get picked up, arrested, whose names continually get dragged out there, who continually lose a decade of their life fighting the Crown, who's trying to overstep its bounds. So, to the minister, can he see the potential threat to a Satanich person who now is facing not only wildlife charges, but also charges under Section 5 of the Firearms Violence Prevention Act?
Minister.
Thank you, Honourable Chair. And I appreciate the members' questioning in this, but I want to make it clear, as I said a few moments ago, this section is replacing an existing section in the existing legislation, and so the issue that the member raises, that he says is the problem, could have in fact, those charges could have been previously laid under this section that he is talking about in those cases, but the fact is they weren't. This piece of legislation is not hunting legislation. It is dealing with gangs and firearms and firearm safety, and that is its purpose and intent. As the member, treaty rights treaty rights that have also been decided by the court in court cases and have been upheld in court cases will trump this legislation. As I said, there's no intent to do something through the back door. In terms of consultation, one of the reasons why I've said that consultation will continue is to make sure that we are not infringing on those rights. But the other advantage too about what will also happen is that through court cases, and I understand, we want to get away from the court case process, but the fact is that there are court cases, that they evolve rights over time as well, that the regulatory framework has the ability to be flexible and to adapt extremely quickly to changes that may be necessary. But what I've made it clear is that the consultation will continue. We will, the member has indicated from his perspective, the nation that he has been talking about, that consultation is crucial, and that will continue, and that is going to shape if, for example, exemptions are necessary, or if there is issues in the framework that need to be in place, then that will, in fact, that will happen.
Member, Saanich North and the Islands.
So, thank you, Mr. Speaker. Good to see you. I acknowledge and have just been sent Section 9, as the Minister noted, of the Firearms Act, and acknowledge that it was there before. However, we are drafting a new piece of legislation, and this is now going to be put into yet another piece of legislation. This is the opportunity that we have to have done this work in advance of. Post-consultation or consultation in midstream, once the members of this place, and presumably the majority there, has voted in favor of this bill, this will be the framework that conversation happens in. What I'm attempting to inform in this decision and in this process today is that we have an opportunity, before we codify this in legislation, to have had that consultation, and it didn't happen. That was the commitment. The commitment wasn't to do it after the fact, not to do it later. And I think that what's important is that the perspective of the chief in the letter that was written and responded to, actually, by the government just today, was a recognition and an acknowledgement that the behavior of this institution, the behavior of this provincial government, has been to establish or reinvigorate, as the language says, the provincial jurisdiction over hunting rights of the Saanich people, of the Sartla, claiming justification jurisdiction to interfere with their, including mine, treaty hunting rights. So wildlife officers have been out arresting Sartla people, Saanich people, and the court cases that the minister talks about as a remedy are not a remedy at all. They're soul destroying. They require an incredible amount of resources from a people that don't have an incredible amount of resources to fight an institution that has all the resources in the world that it wants. That's not fair. That's why this part of the process needs to be a good one. That's why we made the commitment in the DRIPA to do this work in advance of, so that we could then not have to be in court expending resources that would be better expended on healthcare and on education and on social development and on economic development and all those things. Instead, where our resources are going? Our resources are going to defend our people who have been wrongly arrested for violations of an act that's not applicable to them. And now we're in the process of adding another one, or renewing, to change the language, renewing another one. And we've not done a good job of understanding that this is actually going to, and as the member from Prince George Mackenzie pointed out, the hunting community in general has shown concerns about this. However, the Indigenous hunting community, who have a treaty-protected right, this is going to disproportionately impact them. And I am somewhat dismayed that if the minister's comments that they fully understand the impact that this has on the SARTLIP and they're fully aware of the court cases and the jurisprudence around this from the SARTLIP, to have the chief tell me this morning that no, they've not been consulted directly on this. SARTLIP continues to show up in the Supreme Court of Canada documents. And to just assume that this is not going to impact them because it was a clause or a section in a piece of legislation that currently existed, I find it really troubling. And then when the First Nation reaches out to say, hey, we need to talk about those hunting rights, the response from the Attorney General is, it's before the courts, so we can't talk about it. And what the SARTLIP and what the Saanich have been trying to accomplish with this provincial government is to have a discussion about co-jurisdiction. And so with that, I think that the only remedy for this that could strike the level of confidence that's necessary is for the minister to amend this section to be very clear in the legislation that this does not derogate or abrogate any treaty right. Is the minister prepared to do that in the legislation?
Minister.
Thank you, Honourable Chair. As I said a moment ago, treaty rights trump this legislation. It is an existing, it is in the existing legislation. It's not new. It's going into this new act. We are dealing through regulation any issues that may arise that need to be addressed. And so at this point, I would say that is the approach that we've taken, and it is the approach that we've taken through the consultation process that we did. And I understand the member's concern and about his specific nation, but as I said earlier, and I'll just reiterate, when this legislation was developed, we did go through, Indigenous leadership organizations. As I said, they were the BC Assembly of First Nations, the First Nations Summit, the Union of BC Indian Chiefs, Métis Nation BC, all of whom share those same concern around issues around rights when it comes to hunting. And we've been, and as well as the Treaty First Nations, the Niska Nation. And they are all have that same interest around their hunting rights. And we've made it clear that we will continue the work that was already done, that their work will also continue in ensuring that the obligations we have a responsibility to uphold are in fact upheld. And that the primary purpose of this bill has been regulatory. And so that's the approach that we've been taking. But I am mindful of the member's comments. I'm mindful of his concerns, and I will follow up with him on them.
Member.
Thank you, Mr. Speaker. I'm very troubled that the minister continues to use the defense of treaty rights in court as a remedy when we have a remedy in front of us that is much cleaner, requires far less of an individual's soul to be destroyed in the process, that requires far less resources from an Indigenous nation to be expended to defend those rights. It's troubling to me that after reading out the number of times that our relatives have been arrested and hauled before the courts to defend those treaty rights, only for the next generation to have their name added to that, right? White and Bob, Morris, Sampson, Olson and Morris, Bartleman. Every generation has its defender of the treaty rights. The minister is essentially saying that the next generation after me, after us, will also have to have their defender of the treaty rights. When the minister could put into this act, either at this clause here, clause 5, a note that this does not derogate the rights of Indigenous people, the treaty rights of hunting, and I have an amendment, or an amendment at section 10 to say that that nothing here abrogates or derogates the rights of Indigenous people. We could do that work here today. We could make this clean and clear, and we could ensure that as far as this act goes, we still have a lot of work to do in the renewal of the Wildlife Act, but we could ensure that this act doesn't abrogate or derogate the hunting rights, and to ensure that we are able to achieve what the minister wants to achieve, and that I agree, which is that if this is about gun violence and gang violence in British Columbia, I just am not understanding what the hesitation is, or what the holdback is in putting in a clause, in taking a pause here on this particular clause, and putting in place the language in the legislation at the time at which we're debating it. So it's enshrined in legislation, that protection, because this government, previous governments, the whole government institution has a long way to go to gain the trust and to earn the trust of Indigenous people. We've just started in 2019, and this would be a dramatic step. And I can tell you, there's a lot of concern that's being sent to me about yet another act that we may have to defend ourselves against in the future. And it's now being what's debated. So I ask the minister again, will he pause at this moment with this clause and do the work that was needed to be done in advance, not after the fact, with the people who have been most adversely impacted by this, that his government acknowledges they're aware of, that they've received a letter on, that we currently have a member before the courts on, this generation's Morris Olson, this generation's White Bob, this generation's Bartleman, this generation's Morris, this generation's Jim. Why do we have to keep doing this? Why can we not do this work appropriately as was committed in the Declaration on the Rights of Indigenous Peoples Act? What is the hesitation on behalf of the minister to do this work up front and now, recognizing that this actually has a potential devastating impact on Indigenous people, and yet we could achieve what the minister wants to achieve as long, and in addition to clarifying this very important point on behalf of Indigenous people who continually are getting dragged in front of the courts to expend a huge amount of resources to defend themselves, even after winning the Supreme Court in the Supreme Court of Canada.
Minister.
Thank you, Honourable Chair. And I guess, what I can tell the member is what I've been saying is, look, this legislation has been developed in the context of the existing legislation as it relates to this section. This section is not new. It's not being used to do anything backdoor. It's not going to come into force at the earliest until spring of 2022, which allows for, as I have said, the time for additional consultation to take place around any issues that may arise, and that's the process that gives us, I think, the greatest flexibility to address issues that need to be dealt with. The reality is that in the development of this, as I've already stated, we have gone out and met, and I listed them for the member now, all the different groups and leadership groups, nations, about this legislation. And so, I think the path that we have taken and dealing with is the right approach, and we will continue to, as I've said, to ensure that it's implemented in a way, not in a way that respects the rights and treaty obligations that exist and will continue to exist. And as I've said repeatedly, they trump this legislation. Like, this legislation does not take away from them, nor does this legislation seek in any way to take away from those rights and treaty rights that exist and will continue to exist.
Member.
So thank you, and thank you to the Minister for the response. Recognizing that this bill wouldn't be, could be enacted now, but wouldn't be regulated until 2022, I'm not sure, I think, this is eerily reminiscent of previous conversations that we've had around this, which is around the fact that I, as a legislator, and I think all of my colleagues, all 87 of my colleagues in this place, need to be put on notice here that voting in favor of this now is moving forward a process that the previous Parliament agreed we wouldn't do anymore. Agreed that we wouldn't do consultation after the fact or consultation, and it has to be acknowledged that the discussion about the regulations is substantially different than the discussion about the legislation. Because had that been a robust conversation with our chief, with our legal advisors in the room, of the Husseinich Leadership Council, of the Chatlip, the Sartlip chief, then they could have at that time acknowledged the fact that there is an increased, recognizing that this is not designed for hunting, that there is an act, but it could be used. And I think that that is the most important aspect of this, is that because it hasn't doesn't mean it won't. And that's the threat to Indigenous people who have a treaty-protected hunting right. The other threat to putting our head down and proceeding and passing this vote is there's no way to unwind that once it's in place. We then accept that the legislation as it was voted on is the legislation that we are regulating. Whereas if we paused and had that conversation in a more thoughtful way, or the government had a thoughtful way, I'm raising the fact that our chief has told me he's not been consulted. I'm acknowledging the fact that the minister has said that he understands and that the government understands and recognizes, and I am adding further emphasis to the fact that the process, when the minister says that this legislation doesn't trump treaty rights, He's not acknowledging the incredible effort it takes to defend those treaty rights. That's something that I've witnessed. That's something that I know all too well. That's something that our families in Husseinich know and understand, the amount of resources that it takes to defend our rights. So while the minister can stand here today in this House and say, it doesn't, don't worry, it doesn't trump it, that doesn't mean that one of our people can't be picked up on a charge and then their life spiral into an incredibly difficult decade of defending a right that the minister stood here today and told us we all acknowledge exists. But it requires a court process to defend and to win. And, might I add, when you do win, like White and Bob, like Morris Olson, like Saanich Bay Marina, like all the court cases that the government has on the record because my chief wrote them about it in February, when you do win, it doesn't matter. Because the government picks up the next guy, picks up the next hunter. To start that process, the legal Groundhog Day starts all over again. So all of my colleagues here who are poised to vote in favor of this without the legislation should be on notice that it is in contravention to the commitment that we made to the DRIPA, to the Declaration on the Rights of Indigenous Peoples Act, where we said there's going to be a new process for new legislation and a new process for old legislation that's being reviewed in this place. And it is on the record that the minister acknowledges that that he understands the full context of just how involved Sartlip as an Indigenous nation and the Husseinich as a collection of villages within the Husseinich nation are involved in this, and yet they're not the names on this act, on the consultation. There was no consultation, even though Sartlip continues to show up in the jurisprudence. They weren't part of that consultation. That must make everybody in this place feel really nervous about proceeding with this bill. And again, to point out, this is not about hunting per se. That work's still to come. But the impact of this, the firearms, and I have amendments in front of me. I'm prepared to amend this bill. However, I feel really uncomfortable doing it. Because in the process of the last 4 days, that's not the appropriate amount of time to sit down and have a conversation. It shouldn't be on me to have that consultation with the Indigenous nation who has so often showed up in the jurisprudence, whose so much of their money has been invested in defending their members. And I don't even know, I can't even tell you if this language is the language that's appropriate. It's the language that we were able to put together on the short notice of a few days here in this place. So even it does disservice to the bigger conversation that needs to be had here. Do you amend Section 5 or Clause 5? Or do you amend Clause 10, Section 10? I have amendments for both of those. I think the prudent thing to do here is to pause. We're here for a long time this spring and this summer. Pause. The minister can reach out to Chief Don Tom, who's the chief of Sartlip, but also has a leadership role in our province. Sit down with the lawyers, have the conversation. He may find out that this was a good process because they learned something. Might find out that nothing needs to be changed at all because the chief says that. But I can tell you right now that the text messages that I have and the conversations that I have is a great deal of concern. That is not the appropriate kind of atmosphere to be pressing ahead and say, don't worry, we'll do it in regulation. Because as we've seen, regulations can change with the stroke of a pen. Legislation takes an appropriate amount of time. So I'm really, really hesitant to put any amendments on the table in case I don't get this legal language exactly right. Is it Section 35 of the Constitution? Is it the treaty-protected rights of the Husseinich? Is it treaty rights writ large across the province? I don't know how, in this language that I have in front of me, to properly identify the protection that needs to be in place. I just know that there's a great deal of concern being raised to me that there is an increased vulnerability, and the people who will be disproportionately impacted by that are the people that have been defending themselves in the court when this province arrests them and drags them all the way to the Supreme Court of Canada, generation after generation after generation. That should be enough to just press pause for a few minutes, to take a deep breath. And I ask all of my colleagues from all sides of the House, please do not support moving this along until that important and good work is done. So I ask the minister one final time, will he pause this? This is the best possible outcome. Even if nothing comes of it, it is a few moments in time in this legislative precinct. It is a blip on the radar of this place, but it means a lot to the building of trust with Indigenous nations in this province. To say, you know what? Your issues are as big as the issues that we have in this place as we're making legislation. The important work of this place isn't too great for an Indigenous nation who has expended an incredible amount of resources to defend themselves, because it will cause no comfort to them to hear the minister say, oh, don't worry, because this law doesn't trump the treaty. The treaty still stands. Well, in order for us to defend in order for the Saanich people to defend themselves with the treaty, they got to spend a decade in court. They got to go to Ottawa. So, will we take a pause, take a breath? Will the minister commit to having that conversation, or do I have to put these less than perfect amendments on the table to continue this conversation and to try to slow this process down a little bit so that that conversation can be appropriately had with the appropriate chief?
Minister.
Thank you, Honourable Chair. I appreciate, the member's comments and his concerns, but I want to make a couple of things clear, as I've already said. First off, this isn't new, and I stress that because the concerns that he has raised have not been done through this section, and they are not going to be done through this section. But I do appreciate the members' concerns. I've also outlined the consultation that has taken place, and that during that consultation, those concerns were not raised. I've also outlined to him that it is the spring of 2022 for when this legislation will be implemented, and that on this section and on other sections, because the regulatory process is we think, the best way forward on this particular bill, because it is not a hunting bill, it is a firearms and it is a safety bill. And it is not designed in any way, shape, or form to take away from, as I've said, treaty rights trump this. But having said that, and understanding the genuine concern that the member has, I am prepared at this point to stand this section down and to continue on with other sections of the bill. And I am prepared at this point to do that because I do understand what the member is saying and where he's coming from. And as I said, I want to assure him that there's nothing nefarious in this section. There's nothing, it's not designed to, but at this point, I will stand this section down at this point, and then we can proceed to other sections.
Member Saanich North and the Islands.
Thank you, Mr. Speaker, and thank you to the minister for that commitment and that show of good faith. I will just end this part of this debate on this section with the acknowledgement of where I started in my series of questions and in the information that I've provided today. Every single one of those recent, most of those recent arrests have been on safety-related charges, Section 29 of the Wildlife Act. So part of the challenge is around gun safety. And there has been a long history of jurisprudence around the inherent unsafe practices of the Husseinich hunt. And the Supreme Court of Canada found that there is nothing inherently unsafe. In fact, there's been no incidences to date, thank goodness, about the Husseinich hunt. So just as the minister pointed out that this bill is about safety, this was one of the primary motivating forces behind me standing for so long on this section of the bill today, is because our people are being picked up on safety-related issues, and I'm wary of that. So thank you for that, and I appreciate the minister taking the time, and I certainly hope in the time that this section is stood down that the ministry reach out to the chiefs of the Husseinich nations and to the Douglas Treaty nations, for that matter, on all 14 on Vancouver Island, and make sure that this bill reflects that proper consultation process. Thank you.